Judgment in the appeal of the Queen on the application of Tigere and the Secretary of State for Business, Innovation and Skills.
The appellant came to this country from her native Zambia at the age of 6. She and her mother came because her father had a student visa to study in this country. 2 years later, her father went back to Zambia, but her mother stayed here, and so did she. Unbeknownst to her, they had no right to do so. She went through the whole of the English school system, reception, primary, secondary, and sixth form college. She worked hard and did well. She was head girl of her secondary school, and she gained 7 GCSEs and the equivalent of 3 A-level grades of A star, A, and C. She was offered places at several universities and accepted a place to read international business management at Northumbria University. To do this, she needed a student loan. She applied online and discovered that they needed information about her immigration status. Having taken legal advice, she discovered that she did not qualify for a student loan on 2 counts. First, because she had not been lawfully, ordinarily resident here for 3 years. The authorities had caught up with her and her mother 7 years after they should have left, but had given them temporary admission to the United Kingdom. 2 years after that, and 1 year before her application for a loan, they had been given discretionary leave to remain. But temporary admission does not amount to lawful residence, and so she could not fulfill this criterion then, although she can do so now. And secondly, because she was not settled here, in the sense of having been granted indefinite leave to remain. This is only granted where a person has had discretionary or limited leave to remain here for a probationary period, which in her case is 6 years, but in later cases will be 10 years. She challenged the requirements of, firstly, 3 years lawful residence, and secondly, settled status, as either, firstly, an unjustified interference in her right to education under Article 2 of the First Protocol to the European Convention on Human Rights, or secondly, unjustified discrimination on the ground of her immigration status in her enjoyment of that right, contrary to Article 14 of the Convention. Obviously, she is not the only would-be student in this or a similar situation, and so this case is important for them as well as for her. The court unanimously holds that the requirement of 3 years lawful residence is justified. But by a majority of 3 to 2, it holds that the requirement of indefinite leave to remain is not justified. The aim of the requirement is to target student loans on those who are not only likely to stay on here afterwards and contribute to the economy through their enhanced skills and the taxes they pay, but from whom it will also be easier to collect repayments of the loans through the tax system. The evidence is quite clear that university education benefits not only the individual, but also the economy in a variety of ways. But this particular rule is not rationally connected to that aim, because it excludes students like the appellant who have spent their whole educational lives here, who cannot in reality be obliged to leave the country, nor would they wish to do so, and who will therefore remain here to contribute to the economy and repay their loans. The court therefore allows the appeal and declares that the denial of a student loan to this appellant on this ground would infringe her convention rights. The minority consider that adopting this rule was within the discretionary area of judgment which the courts should allow the government in a case of this sort. The court is now adjourned.